All right, welcome back to another special episode of The Unknown. My name, as always, is Michael Volpe. I report from Chicago, Illinois, and Cook County, Illinois, and michaelvolpe.substack.com, and my broadcast partner, Richard Luthmann, who is somewhere around Fort Myers, Florida, and for some reason he's very proud to live in Lee County, Florida, even though it's named after Robert Edward Lee, the loser of the Civil War. Luthmann, Luthmann substack.com. We're joined by Julie Holburn. We've both interviewed Julie before, and I can't remember what's the Substack. How is it titled? If people want to go find your
Unveiled and
site,
Uncensored.
unveiled and uncensored.substack.com.
Yeah,
Just
Julie Anderson Holburn.
all right. And Julie has been following a story that's in its infancy, but could be the most dramatic judicial story of 2026. Six judges from Orange County, California, where, for full disclosure, not only do you write about, but you have a custody case in, but six judges from Orange County, California, are part of a coordinated recall effort. So I'm going to get, you've got several articles about it. I'm going to get one of them up. But why don't you describe what's happened so far? And I think the most important question for me is what has been done so far to get this recall effort going? And you got the six. Well, first of all, what is this judge's name?
Which one?
Right here,
All
this
of them?
lady. No, let's start with her. What's
Oh,
her
that's
name?
Mary. That's Mary Kreer Vera Papa.
All right. The Nepo judge, because she took over her dad's seat. She's one of the six being recalled. What's this judge's
And
name?
that's Carol Hansen.
She's the second of the six judges. This guy right here.
Stephen Hicklin.
Okay. And this, I believe, is Julie Palafox.
Correct.
All right. And this lady right here, what's her name?
Kim Kimberly Maynard Raso.
And then this lady
And
right
that is the current sitting presiding judge over all of Orange County courts, Maria Hernandez.
Okay. So those are the six judges who are being recalled. But how far in the recall process are we?
It's in the initial stages. So the notice of intent was circulated and gathered roughly between 240 to 260 signatures per judge. That was submitted to the Orange County Voter of Registers, or excuse
Mhm,
me, Register of Voters.
mhm,
And so now it's the petition is in the hands of the Register of Voters, and we're waiting for them to approve that language. It also includes the judge's responses on there. So we have on the actual petition
mhm,
is the language why we want the judges removed, what they've done,
mhm,
what citizens, parents have written about and experienced, and then the judge's response. So once that's approved, it'll come back to the proponents,
mhm.
and the proponents will circulate the petition to get whatever the required number of signatures to place them on a ballot, to have them removed and replaced.
All right, but if I heard you correctly, already so far that have been a little more than 200 signatures per judge.
Right, for the notice of intent. So that
Okay,
is
so
a document.
that's already a little bit significant. Approximately how many
Yes.
people live in Orange County?
Oh my gosh. I don't know that number. Millions. Sorry, I
Okay,
should know that number.
it's a drop in the bucket, but it's not that simple to even get 200 plus signatures. That's why I said it's in its infancy. And so after this
Well, it
notice of
is
an
significant. It is
Mhm,
significant. And in getting the signatures, we had a lot of people who were so happy that somebody was finally doing this. And they shared how disgusted they were with what's going on in Orange County courts and the entire system.
mhm,
And some people were terrified and refused to sign because of their perceived fear of retaliation and targeting,
mhm,
and other things, I guess, that they had heard about that had been circulating in Orange County, with the high level of corruption with the recent Anaheim scandal, the Andrew Doe scandal.
mhm.
So to get 240 to 260 signatures, I think the minimum we actually I should say they actually needed to get, the proponents, was between 50 and 100, so they got significantly more than needed.
And you try to get more because they're always the signatures are often challenged. That's what happens in Chicago in the city
Yes.
council elections. They always challenge them. I want to read to get both sides. I believe this is Judge Hansen's response to the recall effort. Pursuant to Elections Code 11023, Orange County Supervisor Superior Court Judge Carol Hansen files with this BOB page, the elections official of the County of Orange, this answer to the statement of proponents seeking her recall. Do not sign this misleading petition. Don't waste over $8.5 million of your tax dollars. Source Orange County Registrar of Voters. This petition is one of 6 attempting to intimidate judges from doing their sworn duties under the Constitution. I have over 30 years of experience in the law, 8 as a judge. The entire bench of judges in our county support me. I was born and raised in Orange County, and my commitment to fairness is unassailable. Judges must be able to make decisions in your case based on facts and law, not out of fear of influence. Don't let partisans manipulate our system of judges. This petition is an attack on judicial independence and fairness. A special election would cost $8.5 million. Don't let them take away your right to a fair trial. I love and respect our county and my work as a judge. I have dedicated my legal career to public service and helping others. Courtrooms exist to treat people fairly and protect our rights. Judges must remain independent to do this job. I ask you to honor the Constitution and resist this outside influence. Don't let partisans intimidate judges. Keep our courts fair and open to all. Wow. I can't believe you are supporting this partisan effort and trying to stop fairness in the courts. Anything you wanted to say in response to that very strong statement? And then I'm sure Rich has 1 or 2 questions.
Well, I would say that most of their responses were similar. And it's frankly laughable and appalling what they wrote about fairness. That has not been happening in Orange County courts for a very long time. So it's just preposterous to make a statement like that and tell people that, this is affecting fair court hearings. The reason why there's a recall is because what's happening in the courts in Orange County is not fair, is not right, they're not following the law. They're ignoring perjury, they're ignoring fraud, they're violating due process, they're violating constitutional right to parent, they're ignoring child's best interests. They're depleting assets. They're prolonging litigation to deplete assets, whether it's a probate case or a family law case. They are not protecting victims of abuse, whether it's parents or children or the elderly. So,
Before
parents,
Rich asked this question, I didn't want to. I wrote one article about Judge Palafox where she was in the middle of the corruption. It was about Dan Greenberg, and here's what I wrote about Judge Palafox. Dan also had Judge Julie Palafox. I previously referred to Judge Palafox in this post. However, this is the first time I have implicated her in corruption. Dan said she repeatedly violated his rights under the Americans with Disability Act. But the most brazen corrupt act occurred when Judge Palafox stopped the court hearing, left the courtroom to have an ex parte conversation with an unknown party, and returned to the courtroom to assign Dan a guardian ad litem, claiming Dan could no longer handle the case on his own. Dan is about my age. I'm 51. And this occurred several years ago, but you're talking about giving a guy in his 40s who was living on his own, making money, a guardian ad litem, normally for children or the elderly who are incapacitated. So that's what she did in that case. Rich, you, I'm sure, have some questions.
We'll stick on the topic now. And one big topic raised by the responses of the recall petitioners, the judges, is appeals versus accountability. The judges have insisted that the errors that you've been reporting about, Julie, should be corrected by the appellate courts, not the recall election. That's one of their strong arguments. But your reporting highlights a stark disconnect. So does Michael, so does mine, so do a lot of journalists, that the appeals in family court, not just in Orange County, but throughout the nation, are prohibitively expensive. They cost tens of thousands of dollars. They're slow. They move at a snail's pace. They could take 18 to 24 months, sometimes more.
Yes.
And the original orders remain in place. Moreover, appellate courts rarely overturn factual rulings.
Yes.
So appellate courts have no real practical relief in ongoing safety disputes, child safety disputes, those types of issues. My question to you is two-part. Why do appeals so often fail to provide relief? And how does that reality shape the argument that a recall is necessary for accountability?
Okay, well, first off, for appeals, they are incredibly expensive. They do take, north of 2 years or around 2 years. And the problem there is that you have appellate court judges who were previously superior court judges. They all hang out together. And, there isn't what is being done at the trial court level is not being corrected by the appellate court. And it is so rampant that to have one case occasionally overturned is not correcting the situation. And judges actually scoff in the trial court level when they say, oh, well, you can take it to appeal. They actually will be like, you can take it to appeals court, because they know they're not going to overturn it. And it is not an actual remedy. So basically the trial courts, especially in Orange County or California throughout, they just do whatever they want, knowing that they're not going to get caught. The Commission on Judicial Performance, investigates maybe 10% of the complaints, and then maybe in the last 30 years, they've removed 14 judges. When you have 2,000 sitting judges, roughly just under 2,000 sitting judges every year, and in 30 years, they've only removed 14 judges, that's a lot of judges and complaints that they're not doing anything about. So again, you have appeals don't really overturn to the degree that it's corrective or a threat to the trial court judges to get their act together. The Commission on Judicial Performance, which came later after the recall because they were identifying with corruption back in California that the recalls were not effective or efficient and costly and time consuming. So they came up with the Commission on Judicial Performance, who still isn't really doing their job, not even remotely. And so that's, after parents have exhausted all the options, going to the DA, the AG, the FBI, the grand juries, the Board of Supervisors, the media, of course, won't pick anything up, which is why the three of us have a job, right? So I happened to be up at a LA hearing for Giselle Smeal, and a parent volunteer court watcher had mentioned, why don't you guys think about doing recalls? It had never entered my mind until that point about doing a recall for a judge. And that kind of information and communication was shared with parent organizers and court watchers, along with California Family Law Naked Truth. And here we are today. So I don't know if that answered your question.
I think you hit it really, really well. I have a follow-up there.
Okay.
And for the audience that doesn't know much about recall process mechanics, I think the most famous recall in California had to have been Arnold Schwarzenegger. He became governor through a recall election. He recalled Gray Davis, and he went on Jay Leno, and he talked all about that. And I don't think more than that there are a few others. But for those unfamiliar, what are the key steps here? I know we've already passed the first hurdle. The Orange County organizers that you've been working with, they first served each judge with this notice of intention, and that requires 50 signatures. And in this case, you have, I think, over 250 signatures, 5 times as much, to say that you want to have this notice of intention. But then the next task, I believe, after the language that the judges submitted back, is the daunting phase. It's the collection of signatures, and it's thousands upon thousands of voter signatures to qualify for the recall to get onto the ballot. I know in 2015, an Orange County judicial recall attempt failed because the proponents couldn't collect the required 90,000 signatures. So can you walk us through the process? You filed the notice, talk about that, talk about the hurdles now, to getting onto the ballot? I know there's a very good attorney that they hired as well. So talk
Yeah,
to us about some of this stuff.
So the next step was, once the notice of intent was served, was waiting for, I think it was 10 days for the judges if they were going to respond. Because if they respond, that language has to be put on the draft petition along with the reasoning why the proponents want the judges removed. So right now that is sitting with the Registrar of Voters, waiting for their approval. Once that petition with signature lines is approved, then the proponents will go and distribute.
Wait a second. Do you get a chance to object to the statements made by the judges?
That I am not sure about, but I know there is a period of, right now we're in a period of, I think there's 5 more days left going back and forth for corrections.
Because can you object to say, like, are there, I know you're not an election lawyer, but are there things there that can be said that some statements are misleading, or are there reasons for parts of that to be stricken, or what's going on?
Yeah, that's kind of the process that they're in right now. I don't believe any of the proponents have hired an election attorney. I know that the judges hired Mark Rosen, or it appears that they hired him since his name is on all their responses. We all reached out to him for comment. He's not in, at least I'm unaware that he's responded to our questions.
Is Mark Rosen still alive, or is he a ghost? How come I know that I sent the notice, you sent an email, the inquiry asking for this guy just to confirm that he's representing these people. It's pretty clear from the documents Michael just showed that Rosen's name is on it.
Yeah.
That he's not even given any credence to the press. I don't know. Have you heard from him at all?
I have not heard from him. And as we discussed, he represented Andrew Doe's daughter, Rhiannon Doe, during the federal investigation into the embezzlement and bribery scandal that Andrew Doe is now currently in federal prison for.
Who's Andrew Doe for our viewers?
Yeah. Who's Andrew
What?
Doe? Who's Andrew Doe?
Tell us about Andrew Doe.
Oh, he is the former board of supervisor who was removed from his seat and just recently went to federal prison because while he was board of supervisor, he approved contracts funneling, I don't know, approximately 13 million or so to an agency called Viet American Society, which his daughter Rhiannon Doe was an executive officer for. And it turned out that instead of using the money for what it was intended for, to help the elderly and disabled people during COVID, they were buying $1 million homes and cars. And so that was...
Sounds like a Somali daycare.
Right, now, that scandal has a link to the judiciary based on Doe's wife. Who is Doe's wife?
Yes, because and before it got to that point, Andrew Doe was a witness in a case, and he had not disclosed up until that point, and the public did not know, this is a year or two before the indictment, that his wife was even who she was, which is Sherry Pham. At the time, she was the assistant presiding judge. And when all this started to come to light, he threatened a local reporter, Nick Gerda, and long story short, it all washed out, and it came out that he had accepted bribes and was funneling this money and not disclosing that his daughter was an executive officer in the Viet American Society. And because of that and the indictment, his wife, Sherry Pham, stepped down from assistant presiding judge, because normally in Orange County, you just matriculate into the assistant presiding, presiding judge seat. So instead of that, she stepped down from assistant presiding judge and now is a family court judge.
Very interesting. So you've got it up here. Let's talk about my favorite part of the program. Anything to do with history? What is the history of the California recall?
The recall, well, I guess one of the most, with regards to judges, one of the most famous recalls was in 1932 when there were 3 judges, Fleming, Stafford, and Gruen, were caught behaving inappropriately for a judge, and it was like a pay-to-play thing going on. And the Los Angeles bar produced a 47-page report, which I have requested a copy of, and condemning the judges and their immediate removal, which we don't really see that in today's world with the bar agency holding judges accountable. We see them helping to, cover up stuff. They don't seem to take any action like they did back in 1932. And then we move forward to 1986, and that was not an actual recall. It was a retention election where three judges were removed. And then to 2015, specifically in Orange County, we had Judge Mark Kelly, who had made a ruling in a case where a 3-year-old was sodomized by a male family member. And the judge said that giving the male who perpetrated the 3-year-old the minimum sentence, which was 25 years to life, was cruel and unusual punishment. So he only sentenced the boy, I believe, to like 10 years. And then people were outraged by that. Constituents came together with advocacy groups. Todd Spitzer jumped on that. He was a board of supervisor at the time. The DA was Tony Rackauckus. He filed an appeal. For whatever reason, they couldn't get the 90,000 and change worth of signatures. And but it was a really big time because.
Is that what you're looking at, Julie? Are you looking at 90,000 signatures for the 6 judges?
I'm guessing that because that was in 2015. And by the way, there's just over 3 million residents in Orange County. Sorry, I couldn't remember that earlier. But
is it based on residents or registered voters?
No, it's based off of votes cast in the last or relevant election. So we will get those numbers from the Registrar of Voters once the petition is approved. And I'm guessing since 90,000 was back in 2015, and I don't remember, I'd have to look up really quickly.
What is it, 5% of the
I think it's 20 of the votes cast.
20% of the votes cast. Oh,
yeah. So I'm guessing it's probably going to be north of
that is going to entail a large, Mike, that's going to entail a large ground game in order to collect those signatures.
No, if they get it past the next step, that's a very big deal, though, as a friend of mine like
Well, I do know that.
I just want to say if it was a fifth, we'd all be drunk. But let's talk about the most recent judicial recall. Judge Aaron Persky, who was sentencing Brock Turner. I think he was a swimmer at Stanford. And I think something to the effect he comes from a nice family, so I don't want to give him any jail time, even though he was convicted, I think, of rape or something to that effect. And that recall was successful, and Judge Persky is no longer on the bench.
Yeah. Yeah, that was very successful recall. I do want to say that on the what was I going to say? Darn it, you're going to have to edit this out.
All right. Okay, no, it's fine. I want to ask you this question based on your, I guess, rhetorical question. Why recalls were rare and why that's changing? Why do you think it's changing, and why is that changing?
Oh, yeah, I think because of what we've done. Now people are aware. Parents have been reaching out nonstop, not realizing that a recall was even an option in California and across this nation. People are reaching out wanting to do recall, but there's only like 8 states that allow recalls of judges. So I do think, because people are fed up. I mean, if you spend 5 minutes on social media, you can see that there are so many parents and even adult child victims of family court, probate court, juvenile court, CPS, and they've all exhausted all avenues to seek correction and remedies. And so I do think that this is a very big deal, and it's definitely caught the attention of the public across the nation, throughout the state.
You know what the answer is, Julie?
And I've got
Mike, the answer is social media.
Right.
Social media in the last 15 years has allowed people to organize in ways that they've never been able to do before. Presidential elections, congressional elections, recalls, and grassroots funded
All right,
grassroots type.
I think this
Oh,
is
I
a good.
remember what I wanted to say really quickly. Sorry. There is a gubernatorial debate set up January 10th. And I know that a lot of the proponents, along with California Family Law Naked Truth, will be going to get signatures. And I believe they have, a strategy set up to get the signatures. They're determined. They are a very determined group of parents and citizens.
All right. And
Great.
for those who don't know about Persky's case, Turner, that's Brock Turner, was convicted in 2016 of sexually assaulting an unconscious woman behind a dumpster at a fraternity party when he was a student at Stanford University. The crime could have been punished by up to 14 years in prison, as NPR's Tobias Smith had reported. But Persky, following the county probation department's recommendation, sentenced Turner to 6 months in county jail. He only served 6 months because of good behavior. I got one. Are you involved in this recall effort, or are you just covering the recall effort?
I'm covering the recall effort. I did serve the notice of intent. There was somebody who was supposed to serve that morning and they fell out. So I was asked if I would take over managing all of the recall efforts. I did not sign the notice of intent, so I'm not a proponent, but I did serve the notice of intent.
On that point, Julie, but Mike, real quick, on that point, you served the judges, and you said before about retaliation that some people wouldn't sign because of that. What was your experience when you actually brought those notices to the courthouse? What happened?
Well, 4 of the courtrooms were fine and took it no problem, and I handed it to either the clerk or the bailiff. But the other 2 courtrooms, Julie Palafox and Judge Carol Hansen, were basically, the bailiff in Julie Palafox courtroom thumbed through it, and he said in open court, well, proceedings were going on. I'm not going to serve this. I'm not going to give this to her. And, he doesn't get to make that choice. He has to take the paperwork and give it to the court. And he continued to tell me that he was not going to take it or serve her, but they were served in open court. And then the other courtroom Hansen kept her door locked all day. And when we came back around a second time, we knocked on it and the clerk came to the door. And when I handed her the paperwork through it, she shoved it back on me, even though it was in her hand. She tried to shove it back on me and I walked away. I had already walked away, and she actually came out of the courtroom following me, heckling me, telling me she was going to have the sheriffs come after me. And I just reminded her, you're on camera and you've been served.
Wow.
All right. I got a question.
And I just also want to preface that there was somebody else who was supposed to serve. They were unable to do it because they got sick. Mm-hmm. And I called several people that morning to find out, because the other parent who wishes to remain anonymous, who was preparing all the paperwork, the signature forms and all that, asked if I could serve. And after I legally and ethically cleared it with other reporters and editors and a legal consult, real quick one, I decided, let's move forward and serve the judges.
And this group, California Family Law Naked Truth, how would you characterize their role? Is it fair to say they are spearheading this? You have mentioned them in at least 2 of your articles, maybe more. So obviously you think they're important to the recall effort, but what is their role in the recall effort?
Well, I would say that they're a newly formed court reform advocacy group, comprised of parent volunteers. I don't believe there's a membership or anything like that yet. On the website, it says it's a nonprofit.
If it's newly formed, why are you mentioning them as part of the recall effort? What is their role in the effort?
Well, so I guess it's the social media campaign, pushing forward, reaching out to parents. First, it was, social media getting.
They're an organizer or the organizer or the main organizer. So they're very significant in this. Rich, you got a few questions?
Yeah, so this is general, but it's applied to this case as well. You've been at the forefront of breaking stories. You talked about Tar Nolan and others, but you've faced extreme institutional pushback in Orange County. The officials there have questioned whether independent reporters like you or even count as journalists.
Yeah.
And they delay records requests, and
Yeah.
they put up hurdles to access for documents and covering family court issues. Tell us a little bit how you've navigated these challenges. Talk about, your investigative approach and how you gather this evidence and verify with all these people basically aligned against you, with all these systemic issues that you face every day. Tell us a little bit.
It's definitely been very difficult because the public information officer at Orange County Superior Court and court counsel John McCoy, refused to recognize me as a reporter, even though the rule 10.500 that governs records requests and defines who a journalist is very specific, and I qualify as a journalist. I am a journalist, but yet they use that as an excuse openly why they're not providing records requests, and why when they do finally, after tremendous amount of pushback requesting production, they come back with these high costs and fees that they're not even allowed to do per their own court rule 10.500. So we have one document that they wanted me to have to pay $4,200 for, and the most recent one, which is the contracts. We're talking 1 or 2 contracts a year for 10 years, and the payments issued out of those contracts, they wanted $132,000. So that's been really difficult. And
say that again. You asked for some paperwork, and the court sent you a bill for $132,000 just to see paperwork.
Yeah, and this is stuff that's electronically transferred from Orange County Superior Court to the Judicial Council of California for their annual reports. So this isn't like they're going into some warehouse somewhere to go dig through boxes. They have,
even if they were, it wouldn't be $132,000. FOIA, Freedom of Information Act, is a national law. Each locality, state, county, city is supposed to have their version, and all members of the public are supposed to be able to get any publicly available record. You are not supposed to make it cost prohibitive. So really, it violates the spirit and the letter of the law when they charge you $132,000. I've had a request for over $1,000, which was ridiculous and absurd. So $132,000, they're just spitting at you.
Yes.
All right, I got a couple. Go ahead.
But also in Rule 10.5, they say the rule is that they are supposed to help you identify records, and they aren't doing any of that. They're just stonewalling me with either ignoring me, not producing records, or when I push and push, they come back with these outrageous costs and fees.
All right. So if the recall effort gets far enough and the recall is on the ballot, I got 6 judges up there. What would your vote be, Julie? We can't vote. So you're in Orange County. You actually could vote. What would your vote be for each of the 6 judges? Would you recall some, all, none of them?
Oh, no, all of them.
All right. So if you're like, let's say, a prosecutor or making an ad, so try to do it in about 30 seconds. Let's start with Judge Vera Papa. If you're trying to convince the public she should be recalled, how do you convince them?
Well, there will be language on the petition that's specific to parents who've come forward and talked about what she's done in their courtroom. So typically she is, ignoring due process. She's placing children in the care of abusers. She's sealing courtrooms. She's, threatening sanctions, and none of that is in the child's best interest.
Right, and I've witnessed that as well with her. She's one I know well. I forgot this lady's name. What's her name?
Carol Hansen.
All right, same question. If you're about 30 seconds, how are you going to convince the public she should be recalled?
Yeah, I mean, it's across the board. They're all doing the same thing. They're all violating
they're all
due process.
Closing courtrooms, violating due process, and they like to give abusers custody.
Yes.
Wait, 1 second. I have a specific question about Family Code Section 3044. And that's the presumption. You've talked about it a lot, and then how it's being bypassed across the board. And that California Family Code Section 3044, for people who don't know, it creates the legal presumption against awarding custody to a parent with a history of domestic violence. And so it's supposed to keep children out of abusers' hands. But based on your reporting, this 3044 presumption is being ignored or overridden by the judges. Can you talk about that a little bit?
Oh yeah, that's absolutely, completely being ignored across the board. And they're not, it's a 7-prong, there's 7 prongs to 3044 that have to be met. They're not properly applying those 7 prongs. They're ignoring documented abuse and flipping custody to the abusive parent. Also, in addition to that, they weren't tracking any of this until Peaky's Law came along, and they're still not tracking it. And Peaky's Law came into effect about a year ago.
Tell the audience what Peaky's Law is, for those who don't know.
Peaky's Law came about a year, it became effective about a year and a half ago. And it outlaws reunification therapy and reunification camps and techniques, and outlaws flipping custody and cutting off custody to the protective parent. And that is absolutely being ignored, and actually as well scoffed at by judges.
Why did
Peaky's
Law come into existence?
Because
why did it come into
because this little boy died being given to an abusive parent. That's why.
Yeah, the judge, Ana Estevez, is the mother.
Peaky and
the judges were ignoring her requests for a restraining order and the abuse that was taking place.
There are numerous laws, family laws around the country named after people, almost always, like Grayson's Law, for Grace.
Hayden's Law.
Hayden's
Law,
named after kids who were killed
Ohm's Law,
because judges ignored evidence of abuse. Ohm's Law, which also bans reunification therapy. You're right. And we should just one correction.
How about Jennifer's Law in Connecticut, where Jennifer's closed?
And that was Peaky's Law came into effect on January 1st, 2024, so a little more than 2 years ago. And Susan Rubio, a Democrat, was the state legislator who primarily pushed Peaky's Law. Go ahead, Rich. You got any other?
So that's the problem, is we have legislation in place that's not being applied, not being enforced, not being followed, not being tracked, and we finally get something like Peaky's Law that requires education and tracking, and they're still not even doing that. And the Judicial Council of California, who manages all the trial courts and has a $5.5 billion budget, said they needed another $1 million to implement Peaky's Law like 6 months after it became effective. So it's just not being followed. This is why we are where we are, because the courts are not serving justice. They are not protecting children. They are doing the exact opposite.
Yeah. All right. Yeah, go ahead, Rich. You got any other questions?
Yeah, me and Mike talked about this yesterday in prep for the interview, and Mike brought up Persky before, Judge Persky, and Judge Persky's case was so it was throughout, the media reported it widely. Everybody knew Persky became a household name, if not in California, or throughout the country.
Oh yeah,
the egregious nature of this. I don't think that these judges yet, these 6 judges have become household names, even in Orange County, with the exception maybe of Kim Carasso in the Tar-Nolan case. Can you talk a little bit about that and how you think, if my belief, and you tell me what your thoughts on, what your opinion is, if there's any judge here that's primed for a recall because of the media treatment, I think it would be Kim Carasso in the Tar-Nolan case. Can you tell us a little bit about that?
Yeah. What a wild case. Tar-Nolan's case has had several judges. The most recent judge, Kimberly Carasso, came in, I believe it was October or November of 2024. And I had already been covering the Tar-Nolan case for quite a long time before that and reporting on it. And then Kimberly Carasso mid-January hearings. So there was like 4 or 5 days of hearings in January of 2025. And I had inquired about remote access. I had inquired about, because in the middle of this public hearing, because all these hearings had been public, they're highly public, family, couple getting a divorce. Their life was in the media before the divorce, during the catastrophic accident, after the divorce by both parties. And Kimberly Raso decided to seal the court hearing while there was a expert witness on the stand who was not talking about confidential information. He was talking about traumatic brain injury. And so that pissed her off, and she decided to seal the court hearing and threatened both parties about media leaks, simply because I emailed and called the court clerk asking why you are blocking the public from listening to an expert witness. This wasn't child abuse. This wasn't child sexual abuse. It wasn't sexual abuse. It was a traumatic brain injury specialist who is an expert witness who has been in multiple court hearings. And that upset her. So she sealed the documents and the rest of the hearing and threatened sanctions, threatened mistrial, threatened excluding expert witnesses. And yeah, that's outrageous.
I wanted to point out California law presumes court proceedings are open to the public. She's clearly violating California law. I've dealt with this all around the country. Diane Walker in Idaho is notorious for this, shutting down courtrooms anytime she feels like she doesn't like what's being said. And it, in that case, violates the Idaho Constitution. I don't know if that's enough on its own to recall a judge, but it's very, very bad.
Mike, I think I'm hearing two separate things here. It's a misapplication of the law by Kim Raso, but it's also an issue of what we call judicial temperament, and that is clearly something that the voters should be entitled to consider. Is judicial temperament. What is the type of person that's on the bench? Are they going to apply the law uniformly and fairly? Or if they're having a bad day and they hear things they don't like, are they going to dispense unequal justice for no reason whatsoever? And I think that judicial temperament, particularly in Raso's case, may become a very big issue.
I agree with you. And here's what's more. Before she became a judge in 2024, she worked in private practice representing medical institutions and hospitals. So here she
assisted deaf people.
What?
Is she an assisted deaf person? Was she lobbying for assisted deaf?
No, she was representing hospitals and institutions in like malpractice suits. Okay. And here comes in somebody who has TBI, traumatic brain injury, is a quadriplegic, recently became a quadriplegic because of a catastrophic accident that was no fault of hers. And, you know, Raso has a very strong understanding because of her medical background, because originally she was in school in the medical field and then became a lawyer and then represented medical institutions. But she ignored the ADA accommodations of Tar Nolan. She chastised her for her injuries and used that against her in her parenting when, I mean, disabled people aren't kept from their children. They aren't, you know, I mean, it's absurd to hold it against this woman that she has traumatic brain injury and is a quadriplegic and other things that come along with a catastrophic sudden accident, right? And use that as a reason to block her from having custody and contact with her children.
Yeah, totally ludicrous.
In my opinion.
And it violates the ADA, and it is a bogus reason. Speaking of judges who like to close courtrooms, you've dealt with another one, Judge Mary Kreer, Vera Papa. I like to call her the Nepo judge because she is the daughter of retired Judge Ronald Kreer. And when you know it, she took over the judicial seat occupied by Ronald Kreer, but you had a run-in where she closed the courtroom, I believe. What happened there?
Right. Yeah. I believe it was, gosh,
It
what
was, it
what's
was
Kara's
in a case. Well, I've got it.
the Grant
Right,
case.
the Grant case. She claimed that there should be open courtrooms, but then she announced that whatever was about to happen was guided by privacy and HIPAA.
HIPAA.
And as a result, she closed the courtroom, which is a misapplication of HIPAA because HIPAA forbids doctors from releasing medical information to anyone who's not authorized. It has nothing to do with a judge.
Yeah.
And
Well,
I
and
go ahead.
also her husband is like the former mayor of Seal Beach, and they also own Seal Beach Pickleball Association or something. So they have this association, and then they have this Seal Beach tennis and pickleball courts, and that's kind of a big thing. And there was a big article about that a while back about the conflict of interest, since he was on the city council approving, the funding for that. And then you have, her taking over her father's seat, like that's not a problem, or
Right.
an appearance of, inappropriateness on some
Right.
level.
I
And
wanted to read from your article about this case, and I think this happened early of 2025. When this reporter, that's you, attempted to attend today's hearing via remote access, Orange County Public Information Officer Kostas Kalitsitis, if I mispronounced it, I'm sorry, sir, notified this reporter at 1:39 p.m. the case was closed, and then questioned this journalist's credentials. In addition, I would
yeah,
like to clarify to you this ex parte hearing is not a public hearing. After some back and forth, remote access was eventually granted, but upon entry into the virtual courtroom, Judge Kreer Vera Papa immediately announced that the proceeding was, quote, closed to the public, citing HIPAA concerns and the sensitive nature of the discussion. This case remains a closed proceeding with highly sensitive and HIPAA protected information being actively discussed. Judge Vera Papa stated, while the case itself is not deemed confidential, this portion of the matter is, at this time, Department L65 is deemed a closed proceeding. Anyone here from the public or online, we are going to put you in the waiting room. Anyone in the audience, we're going to have you wait outside. And I believe this is the custody case where one set of grandparents got custody. Am I right?
yeah, the
Yeah.
paternal
Yeah.
grandparents had custody while they were awaiting, I believe, maybe a CCI investigation or something to that effect. Who the father's parents, that dad was or is, I believe, a family court judge in another county, a neighboring county.
So
Do you recall
favoritism, but
that?
look, when you give custody to grandparents, it's almost always you're doing something wrong.
Yeah.
All right, so go ahead.
What else? Oh, there was something else I was going to say about that.
So
Shoot.
anything else you know about Judge Vera Papa?
Just that she has lots of reports of her inappropriately sealing the court hearing.
I want to clarify a point for the audience about HIPAA.
Oh,
HIPAA is something that it actually does apply in legal proceedings. I was subpoenaed last year at a hearing, and they wanted me to ask questions. They asked questions to me, and one of the defendants in the hearing, I was a non-party. One of the defendants in the hearing was my physician, my doctor. So I, as someone who was a witness, asserted not only my HIPAA rights, but because I live in Florida, I have healthcare disclosure protections of the Florida Constitution. To the extent that private medical information is going to be released, you need the court to rule on that before it gets released. And so, if they're going to close the court because some HIPAA stuff might come out, that's a bit of a false issue, because all the doctors and hospitals have the HIPAA protections. And before that stuff even gets disclosed, they make an application to the judge and say, Judge, we have HIPAA protected information. We can't disclose it. What do you want us to do about it? And the judge usually pre-decides, you know, the HIPAA stuff is not going to come in, or the HIPAA stuff is going to come in a limited way, or the HIPAA stuff will come in full, but it's going to be protective order. So for to blanketly close a courtroom because of HIPAA is what we call a pretext. It is so overbroad of an interpretation of what's happening and what could happen. It's being used for an improper purpose.
Well, and to that, I believe in that instance in the Grant case, it was really that the minor children were going to testify in chambers or in a closed courtroom, not and so it's like there wasn't a doctor coming to disclose medical information. It was my understanding that the minor children were going to be interviewed in chambers.
And that's fine if the court wants to conduct an in-camera hearing with minor children to protect the minor children's rights. The court has to put that on the record. The court can't just say HIPAA. You give them specific reasons
she doesn't explain.
And also, there's a really important case with an opinion that came out in the Nichols v. Nichols case, and it was specifically about closing family court cases. And it cited that even when parties stipulate to close a hearing, that still isn't enough justification to close a public case. So I don't know.
We do not have star chambers. We have a lot of hearings that are being closed, and that's very wrong. I did an article fairly recently about Judge Vera Papa. She was involved in this case. Carlton Weisskopf lost custody based on a sealed evaluation from a woman named Sue Tompkins. So no one knows what's in this evaluation. The Judge Vera Papa, held a perfunctory hearing. No witnesses were called and decided on an emergency basis based on this report that no one knows what's in the report because she sealed the report, that we should immediately switch custody to temporary sole custody from Carlton to his ex-wife. And a monarch was involved. It's not David Monarch, who I think at one time represented your ex-husband, but his brother, Michael Monarch. And he was similarly heavy-handed in that case. I've done a lot on Vera Papa. She's one of the worst judges. I would definitely be voting against her if I lived in Orange County. I don't know 4 of the judges, but Vera Papa would definitely be voting against. Rich, anything else you wanted to add?
Nothing really on this. Basically, I think we summed up a lot of it. You know, usually what we do, Julie, is we let the person we're interviewing ask themselves a question and then answer it as we're about to wrap things up. So we can give you that courtesy if you'd like.
Ask you guys a question?
No, you're going to ask
yourself a question. You don't have to do it out loud. You can just answer whatever question you've asked yourself. Anything else you wanted to add?
Follow along at home.
Yeah. I wouldn't even know where to begin on what question or what answer to give.
Well, I'll give you one if you want. Okay, I have a good one. Okay, so what has been the greatest challenge for you as a journalist in covering the Orange County courts?
Records requests and retaliation, just for wanting to get the truth out there to help make a difference for Orange County families and children. There is such a drive to shut down anything I'm doing and reporting on and prevent the truth from coming out. And earlier we were talking, you mentioned something about social media having an impact, and you're absolutely right. Social media has had a huge impact on what's happening in our family courts in general, probate court, juvenile court. But that's probably the biggest challenge, and it's been used against me. You know, I filed a new action into my case in February, and they assigned me to Kimberly Raso, even though I had been covering the Tar Nolan case. And
but how are they supposed to assign a judge? You covered all of them. How are they supposed to assign you a judge?
Oh, well, I haven't covered all of them.
Okay.
And
not yet.
So you think there's a way for them to be fair? So you think it's not a coincidence? Rich had something like that with where a judge he was covering suddenly wound up on one of his civil cases.
Let me just say this. Let me say this. Years ago, I started asking for a change of jurisdiction because of the level of public corruption in my personal case that had to do with mold and asbestos lawsuit, and the DA's involvement in my case to cover up a felony assault inflicted on my children and I by my ex-husband. And I started asking back then for a change of jurisdiction, and all they did was, hammer down on me harder, which is what led to me, becoming an advocate and realizing that wasn't enough. And then, becoming a journalist, because nothing was being exposed what was happening to all these families and children in Orange County. I thought when new judges came on, especially filing a new action, they would put me with somebody who I had not covered. And there's plenty. I mean, there's like 100 judges or something on the roster. So, but they specifically put me with Carasso. I moved to disqualify her twice now because there was a conflict of interest. It wasn't even just an appearance of bias. It was definitely a conflict of interest and bias.
Right. No, you've
lied.
covered her
Really?
stuff.
Did she misrepresent that some of the things that were said? She actually basically lied on the record?
Yeah, she lied in written format under oath that she didn't know who I was or what my work was or anything about my work, yet months
She's not supposed
earlier,
to read about, but she's not supposed to be reading about like public like news stories about cases that she's presiding over. So how do you know she was lying?
Oh, come on, Michael.
She's not supposed to be reading. She's not supposed to be reading your articles. If you're writing articles about the Tar Nolan case and she's presiding over it, it is inappropriate and actually disqualifying for her to read your article. How do you know she was?
So here's the thing.
Wait. Let her answer. Go ahead.
Here's the thing. There were court document filings that were filed into the Tar Nolan case where my LinkedIn entire profile with my picture was attached, my Newsbreak profile, and at least one main article on Tar Nolan that Carasso was covering was an exhibit.
At that point, she's required to read the article because it's a part of the court record. Rich, you wanted to jump in.
Michael, 100 times out of 100, you put the judge's name in the article. Today's day and age, with Google Alerts,
they're not supposed to.
Mike, I don't care if they're supposed to or not. The fact of the matter is the appearance of impropriety becomes the issue. And frankly, if the judge says, I don't read that stuff, then they're a moron because everybody else in society,
they're not supposed to read that stuff.
No, when Michael Volpe's name pops up on Google Alerts,
I don't have that kind of ethic. You're not, because then you're introducing things into evidence in your mind that are outside of the court process. That's why you're not supposed to read those articles, because what Julie is saying in the article wasn't said in court. So now you're going to be useless.
Michael, you're taking a 1960s and 1970s view of willful blindness. In the 1960s and 70s, the judges would say,
want judges to be
evil. This is 2025. We're in an internet age.
Want them to be ethical. If you're reading about your own case, that's a huge problem. You're not supposed to be doing that.
They're lying about reading about it. That's the bigger problem, Mike. Lies are bigger problems about the reading. Yeah, sure, I read it. I didn't consider it. I'd rather than say that.
If she's introducing evidence that wasn't introduced in court, that's a huge problem. That's why, because all you can look at as a judge is what's been presented to you in court, not what Julie put in her article.
You're 100% wrong. Judges are you're advocating for a system where judges are playing dumb. Judges can take judicial notice of just about anything. But we have so many judges, especially in the family courts, that are playing dumb. And they're saying the record is limited. And they're excluding things that are basic common sense. We want judges that have common sense. We have 6 judges here. None of them have any common sense.
Right. I'm not arguing
common sense back in the judiciary. And they have the ability to do that. You have judges that are
I agree that judges often read articles about their cases. Go ahead.
It's something that's good. Why? In what fantasy world would anybody live in arguing the limits of a judge's judgment is a good thing?
No, I will call me old-fashioned. A judge should not be reading news articles about cases they're presiding over. I'm sure that the guy in the Kohlberger case was reading about Kohlberger. It influences you, and it's not a way that it should be influencing you.
In 1960, you could say that, Mike. because you got your stuff out of a newspaper. And if you saw the case and, oh, I read the title and I quickly moved on. You can't do it nowadays because everything's so inundated and internet is everywhere. You know, that's how it is, Mike. It's everywhere.
Julie,
the law has to adapt.
Why don't you finish up? Go ahead. That was a good debate.
Well, on that, I just want to say that, you know, my LinkedIn profile was an exhibit in
No,
Tarnowan's
then she knows you, and then that's a
Yeah.
lie. That's why I asked you
And
the
that was
question.
months before
Right.
she signed her verified
Right.
answer.
No,
under
then
penalty
that
of
sounds
perjury
like that's
saying-
perjury.
Right.
That's a
she
big deal. That
Yeah.
in and of itself is probably enough to have that judge removed from the bench to commit perjury that way. All right, guys, thank you for being here.
Thank you for having me.